Selamat sejahtera and good morning to Sir Hafizi and all my fellow friends. I hope everyone are doing well. My name is Spinja anak perempuan Sobuntiang and my partner Nuliana Safia binti Muhammad Azhar. And today we will be presenting a legal analysis based on a recent workplace fatality involving a lift maintenance worker. This presentation will explain the employer's legal responsibilities under the Occupational Safety and Health Act 1994 or OSHA 1994 and how the failure to comply with this responsibility may have contributed to the incident.
Assalamualaikum and good evening to sir. My name is Nuliana Safia binti Muhammad Azhar. So I want to read about introduction. On 29 December 2023, a worker named Artinesh Kumar tragically died while performing lift maintenance work at a shopping mall in Georgetown, Penang. He sustained severe head injuries during the process. Following this incident, the Department of Occupational Safety and Health or DOSH issued a stop work order and launched an investigation under the Occupational Safety and Health Act 1994. This case highlights critical legal issues surrounding workplace safety and employee accountability. In this presentation, I will discuss the relevant section of OSHA 1994, namely Section 50, 60, 70, and 18, and assess whether the employer had failed to fulfill their statutory obligation. Assalamualaikum and good evening.
For the case background, the victims Artinesh Kumar was 28 years old and was employed to carry out lift maintenance work. During the operation, he suffered fatal head injuries, leading to his death at the site. The incident took place in a public area within a shopping mall, which raised not only occupational safety concern but also public safety issue. DOSH promptly intervened by issuing a stop work order and began investigating the employer's level of compliance with OSHA 1994. The central question in this case is whether the employer provided a safe system of work as required by law.
Objective. The main objective of OSHA 1994 is set out in Section 4, which aims to secure the safety, health, and welfare of individuals at work. It also seeks to protect others from risks arising from workplace activity. The Act encourages preventive measures and shared responsibility between employers and employees. In short, OSHA 1994 is designed not to punish after the accident happened, but to help avoid such accidents from happening in the first place.
For Section 50 General Duties of Employers, Section 50 of OSHA 1994 imposes a general duty on every employer to ensure, so far as is practicable, the safety, health, and welfare of their employees while they are at the work. This duty includes providing a safe working environment, ensure safe system of work, supplying personal protective equipment, and offering adequate training and supervision. The phrase, so far as is practicable, means that employer must take all reasonable steps based on available resources and foreseeable risks. In the case of Artinesh Kumar, if no proper risk assessment were conducted and if safety measures were not in place for the lift maintenance work, the employer may have breached Section 50.
Safety and Health Policy. Section 60 requires employers with more than five employees to prepare a written statement of their safety and health policy. This document should outline the company commitment to workplace safety, identify role and responsibility, and explain how risks are to be managed. It must also be communicated clearly to all staff and reviewed regularly. If the employer in this case did not establish such as policy or failed to implement it effectively, This rule constitutes a breach of Section 16.
For the Section 17 duty to protect others, Section 17 of OSHA 1994 extends the employer's duty to individuals who are not employees but may be affected by the company's operation. This includes contractors, visitors, and members of the public. Employer must ensure that their work activity do not expose this individual to risk. In this case, the incident occurred in the public shopping mall. If the area was not properly cordoned off or lacked warning sign, then not only the employee but also the public could have been at risk, suggesting a violation of Section 17.
Safety and Health Policy. Section 16 requires employers with more than five employees to prepare a written statement of their safety and health policy. This document should outline the company commitment to workplace safety, identify role and responsibility, and explain how risks are to be managed. It must also be communicated clearly to all staff and reviewed regularly. If the employer in this case did not establish such as policy or failed to implement it effective, this will constitute a breach of Section 16.
So, next is application to the case. Applying this legal provision to the fact of this case, several issues emerged. First, it is unclear whether proper risk assessment or safety procedures were carried out before the leave maintenance began. Second, the workers may not have received sufficient training or personal protective equipment. Third, the employer may not have implemented a written safety policy. Lastly, the fact that the incident occurred in a public mall raised concern about whether safety measures were in place to protect the public. These factors point to the potential breaches of Section 50, 60, and 70 of OSHA 1994.
Next, case law support. Case law can help reinforce the legal analysis. In Colbingham v. Public Bank 2005, the employer was found liable even though the accident happened outside the workplace premise, as it was connected to work responsibility. This showed that the employer's duty of care is not limited by physical location. In RV Associate Autosco Ltd UK, a contractor tried due to poor safety control. The employer was convicted for exposing non-employees to risk. This case shown that court take a wide and strict view of employer responsibility in insurance safety.
Additional info regarding legal penalties. Section 19 OSHA. Section 19 of OSHA 1994 outlines the penalties for failure to comply with the Act. An employer who violates their safety duties may face a fine not exceeding 50,000, imprisonment for up to 2 years, or both. DOSH may also issue stop work order, require corrective action, and initiate prosecution. These legal consequences are designed to emphasize the seriousness of safety breaches and prevent future negligence.
Last conclusion. The fatal incident involving Artinesh Kumar highlights a clear failure in workplace safety and compliance with the OSH Act 1994. The employer lacked Brain Section 15 by failing to provide a safe system of work, Section 18 by not establishing a written safety policy, and Section 17 by endangering others in a public setting. This case serves a strong reminder that OSHA 1994 is not just legal procedure, it is a framework to protect life. Employer must view safety not only a legal duty, but also has a moral responsibility to prevent future tragedy.